Thank you, Ken Sullivan. Thank you, Judge Sanders. A wonderful introduction. Judge Sanders felt that I added some depth to the tour of the courthouse that he conducted just about 1 year ago. I think that he added a great deal of depth to my understanding of the trial of John Brown, and I consider it a fortunate day when I met Judge Sanders here and he asked me if I would be interested in coming back a year hence when the sesquicentennial commemoration of John Brown's activities in Jefferson County would take place. After arrangements very kindly facilitated by Ken Sullivan and the West Virginia Humanities Council, I agreed to do so. And looking out across this historic courtroom tonight, I'm very happy that I accepted that invitation. I had been prepared to make a few observations about this courthouse and this courtroom, which are really, really very historic, both because of John Brown's trial that took place here, but for other reasons as well. Judge Sanders has covered that very well. I'm going to get right to the story of the trial. And at the outset, I want to tell you the thesis that I'm going to express tonight, which is the thesis of my book titled John Brown's Trial. It is that John Brown's trial was the most important trial in the history of the United States. That's my conclusion after studying it as closely as I could. And that's the purport of my book. I've tried to explain in my book why I believe that to be true, and I'll try to give you a suggestion of why I believe that to be true in my remarks here tonight. John Brown's trial was the first trial in the history of the United States to receive massive attention from national media. It was the first trial in which a defendant was executed for treason against a state as opposed to treason against the United States. It was the first trial in which an accused defendant appealed to a higher law to justify violent crimes. It was a trial that involved more than just a determination of an individual's guilt or innocence according to laws laid down in statute books and in case reports. It was a trial that pitted two starkly different moral visions against each other. One of these visions defended the institution of chattel slavery as traditional, necessary, just, and worthy of protection from outside interference, particularly from the outside interference of Northern abolitionists like John Brown. The other condemned slavery as an affront to human rights, a violation of God's law, and an embarrassment to a nation that claimed to be founded on the self-evident truth that all men are created equal. In the course of the trial, Brown did not argue that he was innocent of violating the laws of Virginia, laws that prohibited murder and inciting slaves to rebellion and committing treason against the Commonwealth of Virginia. Instead, he argued that the laws of Virginia that supported and protected slavery, laws that condemned hundreds of thousands of men, women, and children to lives of perpetual oppression and degradation solely because of their racial backgrounds, were unjust. The trial gave Brown a unique opportunity to express his views on the subject, and he did so in a manner that inspired Americans all over the country, many even in Virginia, with the realization that he was a man of courage, principle, conviction, and humanitarian impulses. However much they disagreed with him, however deeply they condemned his resort to violence in Harpers Ferry, his trial revealed that he was not a mere thug or cutthroat, as many both North and South had at first believed him. Brown's raid on Harpers Ferry shocked the nation. It outraged Virginians, inspiring them with revulsion and fear. It aroused in slaveholders throughout the South a contempt for Northern abolitionists. At the same time, it convinced Southerners that Northern attacks on slavery were deeply grounded. They would not soon go away. The South had to defend itself against the views represented by Brown, and many Southerners concluded that the only way to do that was to cut the ties that bound the North and the South. This conclusion did not arise from the raid on Harpers Ferry, but from the trial that was conducted here in the Jefferson County Courthouse 150 years ago. To understand Brown's trial, it will be helpful at the outset to explain a few of the key facts about it. First, it was a short trial. It began in the Circuit Court of Jefferson County in the middle of the day on Wednesday, October 26, 1859, just 10 days after Brown launched his raid in Harpers Ferry, 8 days after he was captured, and a week to the day after he was transferred from Harpers Ferry to Charlestown. It continued on Thursday the 27th of October, Friday the 28th, Saturday the 29th, and following a break for Sunday for half a day on Monday the 31st of October, at which time the jury returned its verdict. During most of the trial, Brown was suffering from painful saber wounds, suffered during his capture in Harpers Ferry, and he was unable to stand or sit. Instead, he was forced to attend the trial lying on a cot, covered by a blanket, and at least once he had to be carried across the street from the jail to the courtroom. Now, if you want to know what this trial looked like, imagine a man lying on a cot in the well of this courtroom, unable to sit or to stand, and compelled to listen to a trial going on around him that would result in his hanging. That's what John Brown's trial meant to John Brown himself. In all, 4 days of court time were devoted to the trial. 2 days after the verdict was announced, Brown was brought back into court and asked if he had anything to say before sentence was passed on him. He then delivered his famous last statement, and the judge sentenced him to death by hanging. The sentence was carried out on December 2nd, 1859, in a field just 5 blocks from this courthouse. It was 30 days after the trial was concluded and just short of 5 weeks after it began. This all happened in a remarkably short time, given the circumstances of the case. The indictment presented complicated issues. It took 20 minutes alone for the court clerk to read the indictment in open court. Difficulty issues were raised by the trial, some not previously dealt with in any American court, such as, for example, whether treason could be committed against a state, whether a person who was not a resident of a state and thus owed no allegiance to the state could be tried for treason against that state, whether crimes committed in a federal enclave, such as the U.S. Armory and Arsenal in Harpers Ferry, were properly triable in federal court or in state court, whether it is proper to try a defendant who is suffering from painful wounds and unable to stand or sit while he's lying on a cot covered by blankets. The evidence was voluminous, both in terms of oral testimony and documentary evidence. During the 4 days of Brown's trial, 9 attorneys were heard from, and approximately 19 witnesses were examined. It's difficult to determine the exact number of witnesses because there was no official transcript of the testimony. The witnesses' testimony was recorded by newspaper reporters, and sometimes those reports were very accurate, sometimes they were rather hazy. There were 2 prosecuting attorneys and 7 defense attorneys, plus at least a half dozen other lawyers who were peripherally involved in the defense, either helping to procure lawyers for Brown's defense or offering advice from the sidelines or representing some of the other men who were captured with John Brown in Harpers Ferry and brought here for trial. Charles Harding was the Commonwealth Attorney for Jefferson County in 1859, and as such authorized by law to prosecute Brown's case.